declare open this hearing of the House of Representatives Standing Committee on Economics for the review of the 4 major banks and other financial institutions, today focusing on the superannuation sector. The committee last heard from the sector in October 2021. Today the committee will hear from Associate Professor Scott Donald, APRA, APRA, ASIC and Treasury. The focus of today's hearing is the impact of recent amendments made to the Superannuation Industry Supervision Act 1993, which will commonly be referred to as the SIS Act, in particular sections 56.2 and I believe 57.2 as well. As the amendment has now come into effect, the committee is concerned by recent instances of superannuation funds seeking judicial opinions to contravene this provision. The committee wants to know what Australia's regulators are doing to ensure that members' best interests are being considered and that law is being upheld, and what actions they believe superannuation trustees should be taking to fund their penalties. I'd like to outline a number of matters related to the conduct of today's hearing. The hearing is being held via video conference and is being broadcast. Proceedings can be viewed by members of the public from the Parliament's website. The proof and official transcripts of proceedings will be published on the Parliament's website. I remind members of the media of the need to fairly and accurately report the proceedings of the committee. It is essential that all members and witnesses appearing via video conference respect and adhere to the requirements to mute their microphone unless given the call, to ensure that questions and responses are heard in silence. Members and witnesses have been given advice regarding connecting to the video conference. If during the hearings you are disconnected, please follow the provided instructions to rejoin the video conference, or alternatively, the instructions to connect via teleconference. I refer members and witnesses to the House resolution related to procedures for dealing with witnesses at page 127, paragraph 9 of the House of Representatives Standing Orders. The resolution provides that should a witness refuse to answer a question, they should be asked to state the grounds on which they object. The committee may either accept the objection or alternatively deliberate at a future private meeting on whether or not to insist upon an answer. If the committee does consider the matter in private, it may write to the witness with the outcome of its discussion. During the course of the hearing, witnesses may be asked to provide documents at a later stage. If a witness subsequently refuses to provide documents, the committee may meet in private to consider the matter. Under Standing Order 236 of the House of Representatives, the committee has the power to compel witnesses to produce documents where the committee has made a decision that the circumstances warrant such an order. Professor Donald, for the benefit of Hansard, would you please state your full name and the capacity in which you appear before the committee?
Yes, certainly, Mr. Chair. My name is Scott Donald, and I'm an Associate Professor at the University of New South Wales. By way of disclosure, I should note I'm here in my personal capacity. I have served on working groups of both the FSC and AIST, and I consult to Herbert Smith Freehills.
Thank you, Professor Donald. Professor Donald, I remind you that although the committee does not require you to give evidence under oath, the hearings are legal proceedings of the Parliament and warrant the same respect as proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. Normally at this stage I'd invite you to make an opening statement. Can I propose to you that we move to questions directly, and then I'll reserve 5 minutes at the end if there are any issues you'd like to cover off, or would you prefer to make an opening statement?
I had prepared a short opening statement to.
In that case, please proceed.
Thank you. First of all, I should just like to commend the committee on its attention to the issues before it today. I noticed, can someone mute their microphone? I'm getting a lot of. Yeah, right, that's better. Right. As will no doubt become apparent over the course of this morning, the legal rules are very complex. Section 56, the Act effectively stops trustees from being excused from liability for certain types of regulatory penalties, or from dipping into trust assets to pay those penalties. In other words, it's designed to ensure that trustees pay for certain types of sanctions out of their own pockets. The amendment that came into force on January 1 extends the list of the types of penalties that are not indemnifiable out of trust assets. It also affects the operation of what are called exoneration clauses in superfund trust deeds. Importantly, the amended Section 56 applies to all funds, both industry and retail funds. Importantly also, Section 56 has implications for the trustee's use of reserves and the purchase of trustee indemnity insurance, and ultimately that is where the rubber meets the road in this issue. Ensuring that superannuation trustees are accountable is very important. We ought not to impugn trustees for innocent mistakes, nor ought we to go looking for accountability where none is owed. But the trust structure was chosen as the legal basis for superannuation industry in large part because of the way that it focused responsibility and accountability on the office of trustee, and Section 56 and the recent amendments play a really important role in that. And I'd welcome any questions that you may have on the application and detail around that section. Thank you.
Thank you, Professor Donald. I have a few short questions, then I'll pass to the Deputy Chair. I note Dr Molino is also on the line, and for this section at least, I'll attempt to allow all members to ask any questions that they have. Professor Donald, what should a good regulator have done to ensure the best interests of members in relation to what has transpired over Section 56 over the last few months, in your view?
Thank you, Chair. That's a very broad question. We obviously have a Twin Peaks model where we have two different regulators who are actively involved. The prudential regulator has an interest in ensuring that the institutions that are responsible for making financial promises to their members, to their customers, are in a position to do so. The use of fund assets to pay for the expenses of a trustee is a really important part of, I think, prudential regulation, and the best interests duty is a very important part of that. It seems to me that there have been a range of changes over the last, not just 1 year, but many years, that have focused our attention on the way in which trustees are held accountable and the ways in which they can use their money and the money of members to discharge any liabilities that they incur. It's a tremendously complicated area. I think it would deserve some attention to try to make it less complicated, and so that the rules were clearer. If I have concerns about the way in which that has happened over that period, it is that my sense is that APRA in particular hasn't really come to grips with that complexity. And so it's playing catch up to a large extent in trying to understand what's going on.
Okay. Should ASIC or APRA have acted as a contradictor in these cases?
There are a range of ways in which the case. Well, can we just take a step back for a second and understand what the trustees have sought to do? Because we're focusing our attention on the 9 trustees so far, and there are others in train, I understand, who have gone to the court to seek to have the court bless what they've done. In my view, that's an entirely appropriate thing for the trustees to have done, insofar as they've gone to an independent judicial body to get clarity on what's appropriate and to have that blessed. There may well be other trustees who have not gone down that route, and we should not therefore impugn the 9 who have gone to get that level of scrutiny and blessing, because they very clearly have gone to expose what they're doing to the scrutiny of the law and to try to act in a way that is appropriate. What they have done in many cases is gone to seek judicial advice. Where they go to get judicial advice, it is open to the regulators to be engaged in a variety of roles, either as an amicus curiae or possibly as a contradictor or as a form contradictor. It seems to me that it's entirely appropriate that APRA do so. We cannot tell from the reports that have been provided to the publicly exactly everything that APRA advised. Some of that has been suppressed because of confidentiality issues. But it seems to me that APRA has been present, has had an opportunity to make its representations, and from what we can see, did provide quite detailed written representations about what they expected to see trustees do. We should note that because of the way that the superannuation system has grown, each fund has a unique set of rules. Its trustees are quite different, its arrangements are quite different. And so it's very difficult to provide a single example for how all trustees ought to act. They have to act in the context, not just the best interest of their members, but also the powers that they're provided under their deed and the way that their arrangements work.
So I'm just interested, though, in your view, when BT, when AMP, when a whole list of other funds sought to change the terms of their deed, ASIC insisted that they inform members of what they were doing. In the Q Super case, ASIC made no representations during that case, and His Honour in that particular decision said that it would be onerous for the trustee to inform the 217,000 members. Do you not think that there is problems when you have an ex parte legal proceeding in which members are not advised that they will have money deducted from their accounts?
I believe what the court was doing there was commenting on the fact that the members had not been given an opportunity to make representations to the court. I think that would still be anticipated that all of the trustees would disclose to their members after the event what had happened, which would also have been the instructions that I imagine that I don't know in detail the examples you're giving in terms of AMP.
So, Professor Donald, I'm sorry to interrupt. So what you're submitting to this committee is that it's too onerous, according to the submissions to the court, it's too onerous to inform members prior to changing the deed, but once the deed's changed and there's nothing they can do about it, then it's okay to let them know. You don't see a problem with that?
With respect, I didn't say that.
Right.
With respect, what I did say was that was what the court had said, was that the need for timeliness and expense and so on, and the court's view justified that.
So how is it any less timely or less expensive to inform members before something is done as opposed to after it? Where's the cost efficiency in that?
Well, there was a deadline here that things had to be done by the 1st of January, or the trustee was going to be exposed. So that does change things a little bit.
Well, hang on.
But I think we also need, with respect, I think we also need to recognise that what's going on here is that the trustees are declaring a fee to enable them to meet some liabilities that they may face in the future.
I appreciate
which makes it transparent. In the past, many of those fees may have been paid from monies without that transparency. So in fact, the amendments that the government made have improved the transparency of the system insofar as we can now see that that's going on, and that it's not happening in the background in some dark corner of a reserve somewhere. So I think in that respect, Section 56 has been very effective in bringing to the fore the fact that all trustees, including those in the retail side, need to make allowance for the fact that they may find themselves subject to liabilities and have an ability to deal with that.
Professor Donald, I'm somewhat confused by your reasoning here. You're saying that there was a time constraint, which I appreciate, but did the government not delay the implementation of these laws for 12 months?
Yes, they did.
So what was the time constraint exactly?
The time constraint was to try to get things in right before the courts and considered by that date. So
in other words, if you wait long enough, then you can argue in front of the courts that you shouldn't have to inform members.
No, I'm not suggesting that.
Well, you were arguing with me that you were submitting to the committee that one of the reasons that it was onerous for them to let members know that they would now be facing a new charge, and whether they would agree to that or not, was because they were up against a deadline. But that deadline had been moved once. It was 2 years in the making, and I'm just wondering why the court would take that into account. And I guess I
can't justify I'm not going to try and defend what the court came to in that. That was a conclusion based on the evidence before them that the court took. I'm very much in favour of trustees being as clear in their communications to members as they can be at an appropriate time. There was considerable work, as anyone in the industry would know, over the first part of last year to identify what was the appropriate way to respond to the changes to Section 56, and then there are the court processes to go through. So good use was made of the time, in my opinion. Whether members could have been informed earlier, I think that's a decision the trustees need to make.
No, I'm sorry, Professor Donald. I'm afraid I can't let that stand. Members weren't informed. It's not could they have been informed, they weren't informed. And what I'm finding difficult about this submission is that they weren't informed, because it was onerous in both cost terms and time terms. But they had 2 years in which to make these changes, And then I'm being told that, well, now it's not too costly once we've got the charges through. Professor Donald, and what I don't understand is why ASIC and APRA didn't make those submissions to the court.
You'll have to ask them as to why they didn't make those
Right.
submissions.
Well, let me ask you this question, a more broader question then. Do you think APRA and ASIC have lived up to what the community would expect a good regulator to do to protect their financial interests?
Again, that's a very broad question. I think the Royal Commission identified a range of ways in which the regulators needed to up their game to be more engaged with the industry, to pursue circumstances where they thought that there was something that wasn't working the way that it ought to, or to pursue circumstances where there was a need for remedy or redress. They have both. Well, ASIC has done that very, very clearly. APRA has suggested, and most of APRA's work is done behind closed doors. APRA has suggested that it has engaged with these matters. As I've suggested in my earlier testimony, I do believe APRA has been playing catch up in this area. The whole area of how reserves are used, how insurance is purchased, how fees and costs, sanctions are paid for, has been something that could have been attended to well before this. But it seems to me now that that's something that is on their radar and that they are pursuing.
Sounds a bit like the horse after the horse has bolted. But look, I've just got two other questions and then I'll hand to the Deputy Chair. And Ms Hammond has indicated she has a question too. Does creating an indemnity insurance market for penalties risk creating moral hazard in the way a fund exercises its duties if it is protected against losses by the insurer?
That's a very good question, and the key question has to be who pays for the insurance. It seems to me that one of the concerns that I and others have had for some time is that prohibiting funds, the trustees, from using members' assets to meet sanctions would be undermined if you then allowed them to use member funds to buy the insurance that would pay out on those liabilities.
Okay.
The law isn't. I want to stress the law in this area is very complicated, and it's not at all clear that the outcomes that you might want would be achieved in all situations. And I think it would be worthwhile getting some clarity in that space to ensure that doesn't happen.
Thank you. Given the cost of operating and insurer profit that would be required to create an indemnity insurance market for penalties, what cost savings, if any, would result from this model versus funds directly levying members to pay penalties?
I'm not in a position to derive some kind of cost and benefit analysis on different options. What I would say is that indemnity insurance markets, indemnity insurance markets have been in play for some, in the past.
Yeah, it stands to reason that given the profit margin, distribution costs, etc., that an insurer has to bring to bear in a market, that it would be more expensive than levying members directly. Cost of capital, etc.
I don't think I could accept that proposition on its face, because
really?
we permit indemnity insurance in a wide range of circumstances, and the advantage of seeking insurance rather than self-insuring, which is I think what you're talking about, is that you get the diversity of the pool, of the insurance pool. So I think whilst I'm sure there are cheaper and more expensive ways to do this, I'm not sure that I would accept your proposition at face value.
Thank you, Professor. Dr. Lee.
Thanks very much, Chair. I should say at the outset, the Chair's introduction referred to the committee's concerns. As best I can tell, this is a hearing driven by the Chair's concerns. The Labor members in the committee don't share the Chair's concerns, and given that there are 4 coalition members, of whom only one is with us at the moment, I hazard a guess that perhaps not even all of the coalition colleagues of Mr. Falinski share his concerns.
Is there a question, Dr. Lee?
So it's more, just to be clear, that we're here with the on a Falinski frolic, and doing our best to work through those issues. I wonder, Dr. Donald, whether you might help us by just outlining to the committee why the changes to section 56 and 57 were put in place in the first place?
Thank you, Dr. Lee. I think you're asking me to justify why the government put those provisions in place, and I think perhaps I'm not the right person to answer that. I can describe what effect they have. They do have the effect of trying to shore up the duties that we expect of trustees, and to ensure that they're not excludable, and two, that they're not paid for directly out of fund assets or members' assets without there being transparency that that's what's happening. And in that respect, I think that's to be welcome. And I think the fact that the major super funds that we've seen approach the court for their guidance, I think they accept that. That's part of what they've done. Is I don't think they're contesting that at all.
Yeah, I guess the context I was seeking to draw you out on was the IOOF scandal, in which it was revealed that IOOF was paying regulatory fines from members' money, which then led to the recommendation to the Hayne Royal Commission that there be changes so that you couldn't pay fines out of members' money. But the complication that if you're a for-profit fund, you have a parent company that can pay the fines. If you're a not-for-profit fund, then you don't have a parent. Everything goes back to the members, and so it was necessary for to either change the trust deed or to have directors put in a position where a director of a not-for-profit fund would potentially face a massive personal liability in the way a director of a for-profit fund wouldn't. Is that a reasonable summation of why the not-for-profit funds are now approaching courts to look for changes in their trust deeds?
Well, Dr. Lee, as you know, there's no magic pudding here. There's no money you can draw from anywhere. If a sanction's incurred, the money has to come from somewhere. In the retail funds, it will come from the capital or from the parents providing that, and that's built up from the fees that the retail funds have charged over the years. Now we have a situation where at least the ones that we've seen, some of the larger industry funds are now going to levy a fee also, which will enable them to be in the same position as the retail funds, to be able to meet those costs out of a dedicated pool of assets that addresses that risk. So in that sense, it's been very effective at leveling the playing field, I think, in there. There were, of course, other issues in the IOOF case to do with the way in which the group worked, and the indemnities and the exoneration clauses worked. And it's unclear to me, because I haven't obviously gone through all the details of the deeds and things that IOOF was working under, whether those would operate differently under this new regime, and whether they would be enforceable or not.
But there was then a fairly rigorous process that the not-for-profit funds went through to look at how to change their trust deeds, wasn't there? I mean, this is not something where they've been acting without engagement with legal advice and the regulators. As I understand it, everybody understood that this issue would arise, and while there's different views as to how the not-for-profit funds should have handled it, relatively few people think that the solution is for not-for-profit funds to make the trustees personally liable for every regulatory fine.
I think that, yes, that's correct. And I should emphasise that it's not just the industry funds that are affected by this amendment. Retail funds are also. They also have sought legal advice and have had discussions with the regulator to ensure that they're doing exactly what it is that the government appears to be trying to achieve. So I think that I do think that there remain wrinkles and gaps in that regulatory scheme, but I do think that the trustees have endeavoured to take the right advice and to engage the regulator in ways to be clear what the regulator expects.
Is there a risk that if the trust deeds weren't changed, that the liability might flow through to the employer and the employee groups, which from whom the directors are drawn? So the AIG and the ACTU could directly face liability?
It would be very unusual for a nominating body in any structure, whether it's a superannuation structure or any other structure. We have nominating processes across the corporate landscape, for a nominator to be held liable for the conduct of its nominees if those nominees have incurred some sanction for their conduct, unless you could find some involvement, some reason why you would attach that liability to the nominating group. So I don't think it was likely before the amendment that you would have an ability to go after the nominees, whether it's an employer nominee or a nominating an industry association or some other group that was empowered to nominate members to a board.
Yeah, sorry.
I may have misunderstood
Do I make
your
this my
question.
last question? Is it?
No, you can ask as many questions. I just wanted to get some sense of.
Yeah, I'll make this my last question, Chair. I phrased the question poorly there, Dr. Donald. I suppose I'd envisage a situation in which a nominee of AIG effectively said to AIG, look, if you want me to be your director on a superannuation board, I'm not going to take the risk that I might lose my house. You're going to have to indemnify me of this. And then AIG would potentially face the prospect of dissolution of the Australian Industry Group as a result of needing to pony up for its nominated director.
I guess that's a negotiation that the individuals could have sought to initiate. I think it's the indications that I've heard are that when those conversations were had, the nominating bodies were not keen to do that. I actually think that would have been a problematic solution, and one not that I would support more generally, because we actually want our member trustees and our nominated directors to act independently. We don't want them to feel beholden to whoever it is that's nominated them. We actually want them to act in the best interest of all members. And I think that where you have, the more ties you have back to that nominating body, the more likely it is that those individuals would be looking over their shoulder, trying to do the thing that, whether it's an employer association, a trade union or whatever, they'd be looking over their shoulder the whole time. And I think that, that I don't think is in the interests of members. I think all members deserve to be served by all directors on the board.
Yeah. Thanks, Chair.
Thank you, Deputy Chair. Ms Hammond, you had some questions. Are you there?
Yes, thank you, Chair, and thank you, Professor. I just want to start off with a reference to the Deputy Chair's, I think, throwaway comment about a Felinski frolic. I would note that, and I'm sure he didn't intend, that sort of trivialises the issue that our super funds now hold, I think, in excess of 1.4 billion in members' funds. And I think you made the comment that APRA is playing catch-up when it comes to the management and governance and protection of super funds in certain situations. And I think it's right and proper and indeed necessary for us to examine the governance arrangements and who might be paying or how these trustees are set up. And I actually want to focus with you on the trust. Now, we've been talking about, with the trust, I understand that in most of these trustees, directors are not actually voted on, are they?
The nomination procedures, yes, would not usually have a voting procedure. There are funds, there are industry funds and employer funds where there are voting procedures in place. I don't think that applies to any of those that have sought court or judicial opinion. But there are certainly some that do have voting procedures outside that.
Right, and
subset.
Yeah, and unlike corporate law, where there's best practices for how long people should serve on boards, balance of criteria. What sort of regulatory environment are there for directors on trustees? I know APRA has some guidelines I'm aware of, but what are the are there terms? Are there limits of terms? Are there capabilities?
That's been mapped quite carefully by APRA over the past 7 or 8 years, perhaps slightly longer. But I think actually that's one area where APRA has spent a lot of time trying to develop principles and so on. There are no hard rules about when people have to retire, but certainly I'm aware of situations where boards have been encouraged to consider refreshing the board, and they are required on a regular basis to review very carefully the capabilities they have in totality. So a matrix of skills, work out what they've got across the various members to ensure that there aren't gaps where a particular aspect of administering the fund doesn't have expertise on the board that can engage with it. So I think that obviously I can't see the exact details of what they say to each fund, but in terms of a regulatory framework around that, I think that's one of the areas where APRA has spent a lot of time trying to lift standards, to lift processes, to make them more transparent and work better.
Okay, but to your knowledge, has APRA ever taken action or given direction or any penalties imposed?
APRA has been very loath to use formal procedures like imposing penalties or excluding individuals particularly. But I am aware of situations in which APRA has been in contact with boards to discuss issues and been quite, I think, strong in requiring the boards to consider their structure and how they operate.
Right, okay. Now, just coming back to the directors' liability of these trust funds, you mentioned insurance. Insurance is the directors or P&I insurance is available, I would assume.
Yes, you have insurance at 2 levels. You have insurance that the trustee can get itself as a corporation, and you have insurance that the individual directors can get as well.
Right, and so that in those instances of worrying about the personal liability of directors of super funds, is insurance the sole answer, part of an answer?
I think it would be part of the answer at best. Many of those contracts have what we might think of as an excess, an amount of deductible that has to be met from somewhere, and those can be of different sizes. It's also the case that criminal sanctions of certain types can't be insured against. And so there are some residual types of liability that directors could face that insurance wouldn't satisfy entirely. And so that's one of the reasons why it's very useful to have some capital in the trustee that can assist in appropriate circumstances, and not all circumstances, but in appropriate circumstances to meet some of those liabilities.
Although I think there would be a general expectation, wouldn't there, if somebody has committed a crime or been involved in the commission of a criminal offence, that they should actually personally pay the price, shouldn't they?
I think that's right. Yes, absolutely.
Yeah. Okay, so getting back to it, the trustee, and you made a comment at the beginning, do you think that the trust form, I think you said something like, the trust was chosen as the format for many of these super funds. Do you think it is the appropriate, given how super has grown and the amount of money that they now are responsible for, do you think it is an appropriate mechanism going forward, or do you think there should be more regulation?
I think the trust structure is appropriate, and I've thought that for some time. Since it came in, I think it is appropriate. It is appropriate also that there be regulatory measures that buttress and support that trust structure. And we've seen, over time, we've seen an increase in that. I think and I'm not on the record elsewhere having said this, I think the big problem is that we don't try, every time there's a scandal comes, we try and introduce a new regime and additional rules rather than actually prosecute the circumstances that gave rise to the scandal. And I think just adding more rules doesn't necessarily do that. I should say, to be clear, I'm not suggesting for a second that this amendment, the Section 56 amendment, is like that, is of that kind. But there are other examples, obviously, where the response has been to just add more rules, and all that does is it doesn't necessarily affect those who weren't going to follow the rules anyway. It just puts greater
Yeah.
burdens on those who were trying to do the right thing from the start. So I think there's a real problem with that. And that's one of the reasons why the reference to the Australian Law Reform Commission has been necessary, to have a look at the complexity of corporate law and financial services law particularly.
Yes,
There's
thank
just
you.
too many layers.
And with that sort of context, is that why you also made the comment that APRA was sort of playing catch up in this area?
No, I think that's with respect. I think that's a slightly different issue. I think APRA, for much of the early part of its life, conceived of itself very much as a prudential regulator with a more of a financial and economics understanding of its role, and really underplayed the role that the law could play in helping it to enforce its rules. I think that realization changed somewhat. Mr. Hayne helped to change that, and as a result, there has been a change in APRA's stance, but over the last few years. But these issues around reserves, around how expenses are recognised and paid for, and so on, that's been around for a long time, and should have been, I think, addressed earlier.
Yeah, thank you.
Ms.
Chair, I'm
Hammond,
aware
thank
of
you.
time. I'll stop.
Dr. Molino, and I've got one question at the end, but you have a couple of questions, Dr. Molino.
Thanks, and thanks for your evidence today, Dr. Donald. Look, I just wanted to just follow up on a couple of issues very briefly. So I just wanted to, you had a discussion with the Deputy Chair about how it would be unusual for a nominator to be held liable, particularly in the context of employer groups or employee organisations nominating people. Just, I guess, stepping back a bit, I mean, one of the distinctions also between nominating organisations and parent entities that's relevant, isn't it, is that a parent entity has a significant financial stake in a fund, whereas a nominating entity is just nominating members to a board. And as you say, you want that process to occur in such a way that they are independent. That's an important distinction, isn't it?
I think, yes, that is an important distinction at law. Yes.
Yeah. And so the only other question was, I mean, as you've noted, it's a complex area, and there are any number of ways in which, I think, I don't want to put words in your mouth, but I think you agreed with Dr. Lee that I don't think many people think it's workable for individual trustees to be held liable for the full range of potential exposure. And you used the phrase, I think there's no magic pudding. And again, just going to the context where a parent entity might set aside some funds, and they're not coming out of thin air. Those funds will often be coming from shareholder returns. So, there's a range of possible mechanisms here, but I just wanted you to, I guess, revisit that issue, that there's no magic pudding here. Funds are coming from somewhere. And even in the case where a parent entity might be setting aside funds, they're often coming from shareholders, some of whom will be retail shareholders.
Well, they're coming from past earnings that have built up as retained earnings in the group, some of which would have been actually the fees paid by the members of the super fund themselves.
Yeah.
Obviously, it'll filter through the way that the group finances work, but in a sense, the fees that the retail fund member pays goes to the trustee company, may get paid in dividends to the parent or in other ways. So that ultimately, yes, there is no magic pudding here. And what I think the Section 56 amendment does very, very well, and I think and in this sense, I don't think this is a Felinski frolic, I think was the term that was used earlier. I think
I'm
these
enjoying
really,
the branding. That's fine. I'm enjoying the branding. It's very good. Thank you.
These are really important issues. What liabilities do we think directors ought to face themselves and pay for themselves? Where should the money come from? These are these are the core issues about governance in the superannuation system. The problem is, of course, they're wrapped up in so much complex legislation that to actually come to grips with them, you've got to deal with all of that at once, and that's not an easy task. But I think I think Mr. Felinski's done us a service in terms of throwing the light on this and seeking to have the regulators really explain what it is that they're proposing to do. I'm not suggesting the regulators have necessarily done too much that's wrong, but I think, and certainly the courts, I don't think have done anything that's wrong, but I think it's a really important issue for us to tease out exactly what do we expect in this context.
Yep, thanks.
Thanks,
Jeff.
Dr. Molino. Dr. Donald, I just have one other question, which is, earlier you said that this provision now puts retail and industry super funds on a level playing field in terms of they will both be getting money through fees to pay regulatory fines. But there is another option for retail funds which industry super funds have decided not to avail themselves of, and that is shareholder capital. So in the instance after the Hayne Royal Commission where there was a whole bunch of remediation payments for retail funds, all of them, I believe, went to market to raise more capital. That is something that industry super has decided not to avail themselves of. So it's not really a level playing field, is it?
Well, sorry, there's a lot of distortion there. Some of the resources available to the retail groups has come from the charging of fees in the past. So that's the point I'm making. Is that I think, and yes, they may also have gone to get capital from capital markets, but I'm making the point now that this is much more a level playing field. It's never a perfectly level playing field, obviously, but it's much more of a level playing field, and that the benefit of this change is that, along with the change to accounting standard AASB 1056, is that we can now start to see some of these flows and start to understand what it really does cost to run a superannuation fund in a modern regulatory environment that is, challenging and so on. So I think that's been very, very effective.
Thank you. Thank you, Professor Donald. Thank you for your attendance here today. The Committee Secretariat will be in touch with you in relation to any matters arising out of today's hearing. You will be sent a copy of the transcript of your evidence to which you can make corrections of grammar and fact. I now suspend proceedings for 3 minutes and we will reconvene with APRA, ASIC and Treasury. Thank you. Thank you, Professor Donald.
Thank
you. Please state your full names and capacity in which you appear before the committee. Can we start with APRA, please?
Yes, of course, Chair. Can you hear me clearly?
We can hear you very well, thank you.
Okay, thank you so much.
And now you're on the main screen, so,
Oh, am I huge? Oh, I'm so sorry.
No, that's no problem.
I'm Margaret Cole. I'm the APRA member with primary responsibility for superannuation.
Thank you, Ms. Cole.
And good morning, my name is Lucinda McCann and I'm the Deputy General Counsel of APRA.
Thank you very much. ASIC, Commissioner Press.
Danielle.
You actually were on and now you've muted yourself. Commissioner Press? We might move to you, Ms. Eccleston, while Ms. Press seems to have frozen. Sorry, yes. Sorry, Ms. Eccleston.
Good morning, everyone. My name is Jane Eccleston, and I'm the Senior Executive Leader of the Superannuation Team at ASIC.
Thank you, Ms. Eccleston. Ms. Quinn?
Good morning. So Megan Quinn, Deputy Secretary of Markets Group within Treasury.
And Ms. Kelly, I believe, is your counterpart here today.
Good morning, Lynn Kelly, First Assistant Secretary, Retirement Advice and Investment Division.
Thank you. And Danielle, Commissioner Press, would you like to have another go?
Let's try again. Thank you,
Chair. That's working.
Press, Commissioner of ASIC.
Thank you. So we're going to do this slightly unusually today, where I'm going to take a block of time and focus on one particular agency, and then give a block of time to the Deputy Chair. If there are any members of the government at the end of my questioning who would like to add to that, please let me know. And Dr. Lee will manage the time of his committee members as well. Was there anyone who wished to make a short, I stress, opening statement?
Yes, I do, Chair. Please.
Thank you, Ms. Cole.
Should I go ahead?
Yes, please proceed.
Okay, thank you. I do have some brief opening remarks, noting what I believe are some key points for this committee, subject, of course, to your questions. So first, in APRA's role as prudential regulator, our objective is the safety and stability of the financial system. In respect to superannuation, we're also focused on the critical topic of member outcomes. It's important to recognise that APRA undertakes its supervision in the context of a large and complex system with multiple layers of legislative, prudential conduct and other obligations. To understand the mechanisms that protect member interests requires an understanding of a number of connected and important legal obligations applying to all trustees. The prudential framework, supervision and enforcement are our tools to achieve our objectives. As a public authority, we operate within the law and the boundaries of our powers with propriety and observance of due process. Always mindful of these issues, we have a bias to action to protect members' interests. Statutory provisions are susceptible to interpretation by the courts at the instigation of parties with a relevant interest. APRA cannot and should not prevent this legal process. It can, as it did in relation to this matter, seek to ensure the courts are well appraised of all relevant considerations. Following the passing of the Financial Sector Reform, Payne Royal Commission Response Act in 2020, APRA and ASIC undertook significant engagement with RSE licensees and industry associations to understand the options RSE licensees were exploring to respond to the amended provisions and updated Treasury and Government as appropriate. In late 2021, as you know, several RSE licensees applied to the various state courts for advice and direction regarding amending their trustees to enable the charging of fees, with a view to building a financial contingency reserve on the trustee balance sheet. While some RSE licensees have had a fee charging power in their trustees for many years, this was not the case across all RSE licensees. APRA does not have a zero failure tolerance. It's not our position that we should protect trustees in all circumstances, but consistent with our mandate, failure must be orderly in order to protect beneficiaries and financial system stability. To be clear as to the significance of this issue, without the ability to build and maintain a risk reserve, an otherwise well-run and well-performing trustee could be rendered insolvent by a minor operational administrative error, such as submitting data 1 day late, resulting in a maximum penalty of $11,100. The disorderly failure of an otherwise sound and sustainable licensee would be likely to be severely detrimental to members, as it would likely impose material costs and create significant operational risks. In the case of insolvency, APRA would be required to appoint an acting trustee to prevent adverse impacts on members and ensure stability of the governance of the fund until a new long-term trustee could be identified to be ready to take over. The route to acting trustee is complex, requires a specific license and certain triggers to be satisfied. Distinct from an acting trustee, to install a long-term future trustee to run the fund as a viable going concern takes considerable time. Given legal requirements, including ensuring its existing members are not disadvantaged, such a trustee will need to engage in due diligence. Will also need to be ready to harmonise operations, technology and platforms used for administration. It is not a quick or easy fix. APRA actively sought involvement in the majority of these court cases, appearing as amicus curiae to ensure that the courts were fully appraised of all relevant legal matters, including the new best financial interest duty, the context of the amended provisions and principles of prudent practice. APRA's submissions also emphasised the importance of ensuring that the impact of best financial interests of members was appropriately contemplated by the courts in giving their advice, particularly in the context of setting fees. APRA was also concerned to ensure that trustees explained in each case the other alternatives that have been explored, why they were not taken forward. Based on the facts of the applications, their analysis of the wording of the amended provisions and the relevant legal precedent, the courts concluded that the charging of a fee of this nature is not inconsistent with the amendments to section 56.2 and section 57.2 of this Act. Reasons provided for these decisions were consistent across all judgments. So what is important now is to focus on safeguards to further protect members' financial interests. APRA has published a recent discussion paper, Strengthening Financial Resilience in Superannuation, which is focused on prudent management of financial resources more broadly. Importantly, this paper clearly outlines fee charging principles to inform fee design and setting. The outcomes of this consultation will lay the foundation for evolution in the prudential framework, reflecting both the introduction of APRA's prudential standard SPS 515, strategic planning and member outcomes, and the passage of a number of key legislative reforms directed at protecting member interests, including the new best financial interest duty. In the meantime, APRA expects the fee setting principles to inform decisions around the setting, design, and level of any fees, and for consideration of these principles to be supported by appropriate documentary evidence. These are important principles APRA will apply not just to RSE licensees who have sought Water Creek to amend their trustees, but to all RSE licensees across all manner of fees. And with these opening remarks, we're very happy to take your questions.
Well, that's very generous of you. Thank you, Ms Cole. Commissioner Press, would ASIC like to make a short opening statement, or are you happy to proceed to questions?
Chair, we're happy to proceed to questions.
Thank you very much. And Ms Kelly, will you be leading off for Treasury?
Ms Quinn.
Sorry, is it or Ms Quinn? Sorry, pardon me.
Ms. Quinn today.
Ms Quinn, does Treasury have an opening statement they'd like to?
Chair, we don't have an opening statement, no.
Thank you very much. Thank you. Ms Cole, if I could start with APRA. Could you please provide to the committee the submissions that you made and the underlying legal advice on which you relied in making those submissions to the court cases?
Chair, as regards the legal advice, I believe that we will preserve our legal privilege in that. As regards submissions to the court, if they were made in open court process, I would certainly be in a position to provide them to you.
Well, indeed, Ms Cole, this is one of the concerns of this committee, that a number of the judgments relied on confidential submissions. Did APRA provide confidential submissions in these court cases, and if so, why?
I don't believe we did provide confidential submissions.
Thank you. So there's
Chair.
no reason. So there's no
Made
reason.
our submissions. Yes, I believe you're right. Unless there's a court restriction in any case, I would be very happy to provide APRA's open court submissions, and I will get my legal colleagues to check that and ensure that that's possible.
Thank you. And I'll place on notice that we are formally requesting the legal advice on which those submissions were based. You said that you've been involved in a number of cases. There are 9 cases. Which cases were you not involved in and why?
I will ask my colleague, Ms McCann, to answer that if you want the specific detail, but we were involved in most cases. There were a couple of cases where we were simply repeating the same submissions we'd made in earlier cases. So on just a purely pragmatic, cost-effective basis, we did not actually appear in those cases. We made the same points by a different route is the point, Chair.
Thank you.
If I may just add to that. So in all of the cases that have been heard in the courts to date, APRA has appeared as amicus. We have made submissions. As Ms Cole said, there's a lot of overlap between the submissions that were made because, of course, the legal principles are the same. And we are also represented by counsel in each of these matters before the courts.
Thank you, Ms McCann. Also, Ms Cole, if I could go back to the legal advice question, we're happy to receive that advice on conditions of confidentiality, or we'll receive it in camera if necessary. In the Q Super case and the Australian Super case, the judges in both cases noted that APRA had made submissions, but that you took no position.
I believe we took the position that we, on a reading of the statute, what was proposed was not inconsistent with the statutory terms.
Okay, but in both cases it would be, sorry, Ms Cole.
If that was your question, if that was the import of where you were going then.
The import of where I'm going is that in both instances, the judges involved in those cases felt that APRA provided no guidance as to the interpretation of the law and that you did not take a position though you made a submission.
I don't feel that that's a correct representation. Perhaps Ms.
Well,
McCann.
after I hand to Dr. Lee, I will find the paragraph in which Justice Blue makes that comment in the Australian Super case. You say that you appeared as an amicus curiae of the court, and I applaud your use of Latin. Why did you decide to appear as a friend of the court and not a contradictor?
Because we felt that was the appropriate position for APRA to take, to make the court appraised of the relevant issues in the best financial interests of members. And given the position of the legal advice we had about the wording of the statute and the fact that we did not believe that this approach contradicted the wording of the statute.
Mm-hmm. In Justice Blue's judgment, he notes that you did not believe that the best financial interest duty applied in these cases in your submission.
So I'm not sure I recognise that remark either. Perhaps you could take me to the context of that. I'll be able to answer better, please.
I'll have to do that after I hand to Dr. Lee. What process did you undertake to make the decision to appear as a friend of the court rather than a contradictor on behalf of members?
Well, we took legal advice, as you've heard. Earlier in the year, as been alluded to by Dr. Donald, we spent considerable time engaging with industry bodies and funds and all relevant parties, including Treasury and ASIC, about what was likely to be proposed by the relevant entities in relation to these changes. Then APRA sought legal advice on the direction of travel, if you like, and detailed legal advice about the background to this, or I should say about, the way this was likely to play forward. We had numerous conversations and meetings, as you would expect within APRA, to discuss what we were seeing from the legal advice and what we expected, what we thought the right way forward was, including further discussions with council. And we took the view that the amicus route was the most appropriate route.
So, Ms Cole, is it fair to say that the legal advice advised you that Section 56(2) did not prohibit a fund from charging implementing a new fee to create a fund to indemnify the trustee against regulatory fines and penalties?
Not quite. The legal advice said that Section 56(2) was not inconsistent with the proposals that were being made in each case, some of which were slightly different, but it did not preclude the raising of a fund by way of a fee to make a risk reserve to pay penalties in the future.
Right. You can see.
By Ms McCann, if you can express that better.
Sorry. Yes.
Well, can I jump in there? So that's absolutely the case. And so having received advice, which was to the effect that these types of fee proposals, be they around the introduction of a more general remuneration charge or a specific trustee fee, that they were not inconsistent with Section 56 and 57 and were not, didn't have the characteristics of an indemnity, which is the, if you like, the mischief that those reform or those provisions are directed at. Having formed that view that that's the legal interpretation, we then played the position of being an amicus. So that was to bring to the court's attention, having considered each of the trustee applications and what was being proposed, bring to the court's attention any concerns that we had in relation to each of those proposals. And so these might be things such as, the nature of fees being proposed to be charged to members and no more than is necessary to cover the risk that's been identified, what sort of controls are in place for the money once raised, and also things like whether the trustee had thoroughly explored all other alternatives for raising money.
Okay, so let's just be clear, that's not what the law says. So let me just ask this question. Do you think by declining to act or by merely acting as a friend of the court, members' interests were not adequately represented?
Well, we made sure that in appearing as an amicus to the court that we raised all issues that we considered were pertinent to consideration of the issue before the court.
Okay.
And how members' best financial interests should be protected.
Okay, so do you think it's appropriate for the court to base decisions on information solely provided by trustees who have clearly a conflict in that they would like to avoid having to pay any penalties with their own money?
Well, I think the court process involves the applicant seeking the advice, putting forward its own carefully considered evidence, and that is what I would suggest happened in these cases.
Okay,
So
did
for the
you...
court,
Sorry, Ms
if
Cole.
they wanted to hear,
Sorry, Ms Cole.
if the court wished to hear from other parties, in some cases, court did appoint a contradictor, perhaps even a member representative in some case. That was a matter for the judge and the court to decide, and in most cases, they did that.
So do
But
you
I
think...
can assure you that APRA's submissions to the court were very detailed and thoughtful about the range of issues the court should bear in mind when looking at these applications.
Okay, so did you play a specific role in the Australian Super case?
So APRA or myself?
APRA, sorry.
Excuse me.
APRA.
We were an amicus in the Australian Super case, yes.
You were, so you appeared, not you didn't just make a submission, thanks. In the decision at paragraph 70, the court states, Mr Silk and Mr Schroeder estimated that the direct costs incurred by the fund in this scenario would be in excess of $100 million. The scenario they are talking about is the trustee being replaced because they are insolvent. Do you agree with this statement?
Well, I don't think we have examined all the detail of that calculation, but we would certainly agree with the statement that if a trustee was replaced in the case of Australian Super, there would be very, very considerable costs, which would end up falling on the members. I would agree with that statement.
Okay. The court also held that, and I quote, in the absence of the acquisition by the applicant of substantial capital, it would be rendered insolvent by the imposition of any significant non-indemnifiable penalty, and this would cause very substantial costs and losses to the fund and thereby to the beneficiaries at paragraph 149. How would this be the case? How would those direct costs amount to $100 million?
Well, I can't answer that part of the question specifically as to 100 million, but I think I've already said in the previous answer that I do believe it would result in significant costs to the members if Australian Super was to become insolvent.
All right. So
I tried to outline, Chair, in the opening statement, sorry, I flashed through it very quickly, but we can go into it some more, the distinctions between an acting trustee, a longer-term permanent trustee.
No, you were very...
like suspension of a trustee.
Yep. Oh, no, you were very...
those things are...
No,
those things are not easy, and they are likely to
Yes.
be costly, and those are costs that are likely to fall on members.
Sure. So is it possible the court was misled in that calculation?
I don't have the detail of the basis of the calculation, I'm afraid.
Is that
I feel in reference to the calculation, I believe, or I understand from what I see here in the submissions, that there was advice, external advice to Australian Super from expert superannuation consultants about the nature of these costs.
So the court was provided with a figure of $100 million by the trustees who benefited from this charge, and there was no oversight of that number, just their consultants.
Well, it was their number, Chair. That is incontrovertibly true.
And there were no contradictors there to be able to stand up for members and to say that number may be inflated, or indeed it may be understated.
Can I jump in,
Yes.
Ms Cole?
Yes, Ms McCann.
Chair, there was a contradictor appointed in the Australian Super matter who appeared and made various submissions in relation to the proposal.
Ms McCann, I'm aware of the contradictor who was appointed in that particular instance, and it's hardly fair to say that he was properly resourced in his action, is it?
I can't comment on that, Chair.
But isn't this the point? Shouldn't APRA be able to know these things? I mean, this is a $12 trustee running a $233 billion fund of ordinary, hardworking Australians' money that they will be relying on for retirement. And a justice of the Supreme Court in South Australia was presented with figures, none of which anyone was there on behalf of members to determine whether those figures were fair or not.
I think it's very important that the court were aware of the reserve situation of Australian super. Justice Blue was aware of the very substantial reserves, both general reserves and operational risk reserves of Australian super.
Ms. Cole,
I think I would have to agree with you. I can't dissect the 100 million, but I can say that I believe the costs of managing Australian super out of an insolvency situation would be very significant numbers of millions.
Well, yes, but okay. If that's the case, why does APRA allow a trustee with a mere $12 of share capital continue to run a $233 billion fund? If you are worried about the prudential standard of the trustee, why don't you regulate that?
Well, we do regulate an operational risk financial requirement, Chair. Capital requirements for super fund trustees were, as I understand it, before my time in this role and some years ago, removed by a previous government. The operational risk financial reserve, operational risk reserve came in. We do monitor that closely. We do have prudential standards around it. It was mentioned in the Australian super case. That is a very substantial amount. I think that if there is a desire of Parliament to impose capital requirements, whether they be shareholder capital or specific regulatory capital, that's a policy matter for the government.
Really? It's not a regulatory matter? Because according to your submissions, its incredible costs would be borne by members if the trustee failed. In that case, shouldn't APRA be insisting that trustees are properly capitalised?
In circumstances where a capital requirement was removed specifically by a prior government and replaced by a different mechanism to enable stability, to support stability, I think it would be a matter for government to reinstate a capital requirement. But I do want to put back on a point, please, Chair.
Yes, of course.
In this context, we did publish in November a discussion paper on strengthening financial resilience in superannuation. That doesn't only outline fee-setting principles, it talks about financial resources, purpose and sources more generally. And we have put out there for discussion and consideration by all relevant in this industry, including important stakeholders such as yourselves in this committee, questions around where the sources of financial resource might come from in the future and what would be necessary for APRA to be able to have a lever to require those sources of resource. So that's a critically important paper for engagement by this community. Responses we expect to have by the 22nd of March. I'd encourage all concerned to engage with it and to work so that we can work forward to bring in new prudential requirements around these issues. But I do not believe that we can require third-party shareholder capital by this route. I do think that requires a different form of policy intervention.
Sure, Ms. Cole, but you can't have it both ways. APRA can't have it, sorry, and by you I mean APRA. APRA can't have it both ways. It can't say that it's concerned about the prudential outcomes of a trustee and then simultaneously say that the Parliament doesn't allow you to regulate on prudential matters. So which is it?
No,
you are concerned about the $12 worth of capital or you're not?
I don't recognise the premise of your question, Chair. I'm sorry.
Okay, well...
We obviously are concerned about soundness and stability.
Sorry, Ms. Cole. I fear that you and I will take up 3 hours of everyone's time if we keep it. So if you don't mind, I'll move on. Why would members incur a cost if a trustee was replaced? Is it for those reasons that you outlined in your opening statement?
Yes, it is operational costs essentially around that. If a trustee is replaced, if an acting trustee is put in place, that would tend to be a large firm, a large consulting firm. There are only 3 licensed to be put into that position. They will all charge commercial fees for the work that they do as acting trustee, which could extend over a substantive period of time. The sort of experts they will put in will include people to essentially to have a look at why that trustee reached the stage of needing an acting trustee. So it will be a lot of work by a third party who will charge full commercial rates. That will be a charge to the members' assets.
Okay. So you mentioned operational and risk reserves previously. What's happened to those reserves in the cases that you've been involved in?
Sorry, Chair, do you mean
So the trustees
court
have built,
case?
yeah, well, the trustees have built up reserves over years for a number of purposes. What's happened to those reserves?
They are sitting in, well, different status, I think, for different trustees, including retail trustees, but the ORFR is essentially a reserve that is ring-fenced to certain purposes under the prudential requirements.
Okay. Do changes in trust deeds of the kind undertaken in the cases which have recently occurred apply on a retrospective basis or a prospective basis?
Prospective, I would say. I'm looking at Ms McCann.
Thank
It can
you.
only take place from the date on which it is changed.
Okay. So then funds will not be able to use general reserves or reallocate them towards building up a reserve for penalties?
I think they'll be able to reallocate general reserves. They won't be able to allocate from the ORFR. And that, in fact, is a point worth pausing on, because if they were unable to reallocate from the ORFR, APRA would have additional levers and standards to have transparency and oversight over the use of those reserves.
Okay. So
That would require a minor legislative change, Chair. But I can tell that may be going too far into detail for today.
okay. So to build up a reserve for penalties, is it correct to say that trustees will need to levy a fee on members?
Well, at the moment, they are, as I understand it, the ones subject to the court process are utilising general reserves to ring fence for the penalty fee.
Okay. So then, why has the AFR reported that a spokesman for CBUS has said that the fund, and I quote, intends to fund the trustee fee from reserves and thereby doesn't expect the trustee fee to have any impact on member fees nor investment returns?
I don't know specifically, other than I could look up the size of their reserves, but I should think they have very significant reserves.
All right. So if CBUS could already... Yeah, sorry, Ms Cole. So if CBUS could already use the funds for this purpose, why change the trust deed?
I think to be, sorry, Ms McCann has words on her lips. Go ahead.
So I think the point, Chair, is that absent these changes to the trust deed, they haven't been able to use the reserves for that purpose. So what they've been in essence doing is looking to those existing reserves as we understand it and use them as the source of funds from which to levy the relevant fee.
Yeah, and then you'll get it that time. Sorry, Ms McCann. So then, in that particular case, can I ask this? That makes these changes retrospective, doesn't it? Because they'll be able to use these funds held on reserve for other purposes for a new purpose.
I don't see it operating in that way.
Really? So it was collected for one reason, and now with these changes it can be used for a different reason. That makes it retrospective, doesn't it?
It was collected as a general reserve, and I think can be repurposed for this reason.
So it is retrospective.
That is not how I would characterise
So,
it.
Ms Cole, seriously, you're saying that it was collected for one reason, now it's being repurposed. That's a retrospective change, clearly. Would you prefer me to move
Not as
on?
I see it.
No, you disagree with me? Okay.
I wouldn't characterise it in that way is what I'm saying.
Okay, so you disagree. What justification have funds provided APRA, if any, that the specific quantums being raised by funds are within the best financial interests of members?
I believe that most, probably all of those that applied to the court gave considerable detail about their intention as to the amount they were going to hold as a risk reserve. And we drove them to do that, in fact, by intervening and saying they must tackle that issue.
Okay, so what we have here is, in different court cases, you have a massive difference in quantum. So Australian Super is building a $36 million penalty reserve, and Cbus is building a $93 million penalty reserve. What does Cbus know about what it's been doing that Australian Super doesn't?
Well, I'd expect each of them to do their own calculations, based on their own judgment of risk.
So they have provided you with no information in terms of how this meets their best financial.
I didn't. That is not what I said.
Through
the supervision mechanism. I mean, we're early days following the court process, but through the supervision mechanism here, we already have interactions with the various trustees building the reserve as a result of these. Yes.
All right. So, Ms. Cole, I just want to, and Ms. McCann, I just want as a matter of record on Hansard that the contradictor that you referred to in the Australian Super case was a member with very limited resources who was represented by a barrister and that barrister's previous law firm who are also counsel for Australian Super. Do you think that is an effective contradictor for members' interests in that case?
Well, if I could chime in at first instance, Chair, the regime in South Australia is such that the contradictor role has to be played by a member representative who is, as I think, has to be then paid for by the applying trustee. So that model that you've described is what's provided for under the relevant state.
Thank you, Ms. McCann, but I don't want anyone leaving this committee and listening to this hearing believing that there was an effective contradictor representing the members' interests in that case, because clearly on the face of the facts, that is not true. You had one particular member whose appointment we don't understand how that occurred, being represented by legal counsel who also does work for the trustee.
So that legal counsel, Chair, would be bound by their own considerations of who their client was in that case and their ethical standards.
Thank you, Ms. Cole. Deputy Chair.
Thanks, Chair. Look, I should just say at the outset, there's something quite heartening about having evidence being given by 6 women in this hearing today. Given that Treasury, ASIC and APRA are 3 organisations that have never been headed by a woman, it does suggest that change may be in the air. Can I start with...
a matter of time, I'm sure.
Yes, exactly, yes, and it would not be before time. Can I start with Treasury? Ms. Quinn...
Oh, sorry, Deputy Chair. So you're just going to go generally, because I was then going to come back to ASIC and then Treasury.
Yes, I will. Given that we're closing in 50 minutes, I thought perhaps I'd move around the agencies, if that's all right. Ms. Quinn, as we know, this issue arose because of the IOOF misconduct. The recommendations of the Hayne Royal Commission were therefore to ensure that fines couldn't be paid out of member funds. Then Treasury commenced a consultation process in February 2020 about the changes to Section 56 and 57. Did Treasury receive feedback from lawyers from superannuation funds at that stage, and what was that feedback?
Thank you, Deputy Chair. So just to be clear, this precise change to Section 56 was not a specific recommendation of the Hayne Royal Commission. It did arise as part of implementing a suite of regulatory changes that were related and in the context of the Royal Commission. One element to keep in mind is that this was an expansion of an existing statute. Prior to the Hayne Royal Commission, there was a statute that funds liabilities under the SIS Act were not to be indemnified. And this was expanded to be consistent with the regulatory changes that brought oversight and conduct ASIC in, AFSL licensing regime, and other changes. So we did, as a part of the policy process, in response to the Royal Commission, consult with industry, look at the regulatory environment and make legal changes. As part of the submission process on the exposure draft of the bill, we did receive submissions, and it was generally supported, this change to the bill as it was passed. There was a question in the debate in Parliament about whether the implementation of this change was too hasty, and there was an amendment put to extend the transition period at which funds had to respond to this change, and that was accepted by Parliament. I'll just pause and check with my colleague, Ms Kelly, whether she wanted to add anything.
No, Ms Quinn, that's a very good summary.
Ms Quinn, I'm interested particularly in submissions made by not-for-profit funds around the question of how their trust deeds might need to be amended in order to deal with this issue. When was that raised in the Treasury consultation process?
So my understanding is it was raised in response to the exposure draft legislation. The ISA submitted that they supported the extension and noted that the change was consistent with the existing prohibitions in the SIS Act. The Law Council raised concerns that not-for-profit funds may need to adjust their trustee deeds in response to this law change. But it's fair to say that this change in the legislation arrangements did not receive a significant amount of commentary as part of the exposure draft legislation, given the breadth of the changes that were in that bill.
So when did Treasury first become aware that it would be necessary for not-for-profit funds to change their trust deeds?
We were aware from the very first consideration of this possible change in policy that it was a possibility that some funds may need to do so. But given, as other witnesses have mentioned, the superannuation system is quite complex and every fund has its own trust arrangements, it is the case that only a few funds out of the substantial number possibly need to change their trustees.
So you
but
said
it was always
from
a possibility.
the beginning of the process there, Ms Quinn, so is that February 2020?
So prior to the drafting of the legislation, this was something that we were aware was a possibility.
Could you give me an approximate date?
Certainly prior to November 2019.
And when was the Treasurer's Office first apprised of the possibility that not-for-profit funds would need to change their trust deeds?
So we would have raised this issue as part of our briefing process in relation to the legislation and the policy intent that government had for that legislation. So from November 2019.
So the Treasurer's Office knew from November 2019 that the change in Section 56 and 57 might necessitate not-for-profit funds changing their trust deeds.
So that it may be likely that that trustees would need to consider how they would respond to penalties as a result of the changes in this proposed changes in this Act. That there's a range of options that trustees would explore in response to this change. So there were, and I believe this committee has had evidence from the previous witness, Dr. Donald, and in fact, many of the funds that went through the court case set out the alternative arrangements. So there are many ways that superannuation trustees could build reserves if faced by a penalty, and that those options were explored as part of our advice.
And did Treasury ever give funds an indication of suitable paths to deal with the new trustee risk?
That is not a role. Treasury does not advise the superannuation industry. We advise government.
But did you have conversations with funds as to the way in which they would deal with it, or was it really a one-way thing where they were telling you how they expected to respond, and you were taking that in but not providing anything back?
I wasn't party to those precise discussions, so I'm happy to take that on notice. Typically, we don't provide advice to external parties. We do certainly listen to their concerns.
Ms Cole, can I put the same question to you? Did APRA provide guidance to not-for-profit funds as to suitable paths to deal with the change in the law?
Again, Deputy Chair, I wouldn't characterise that as APRA's role, but what APRA did was facilitate discussions, including a round table of relevant parties in May last year, I believe, to try to work through some of these issues. So I would describe our role as that of a very interested facilitator of a solution.
So that's May 2021, and did...
It may have been, that I know is the date of the round table, Deputy Chair. There may have been other discussions. As you, I think, know, I joined APRA in July 21.
Yes, absolutely. And when did APRA first raise in its communications with the Treasurer's Office that trust deeds of not-for-profit funds might need to be changed to deal with the Section 56, 57 changes?
Well, I'm not aware of anything before my arrival, Chair, but I certainly have had interactions with Treasury since my arrival on this very point.
So from July, you're aware of discussions with the Treasurer's Office on this issue from July 2021, but they might have taken place earlier?
I have no knowledge of anything earlier because I'm speaking from my personal position. I arrived in July and I certainly didn't get onto this on day one, but fairly soon. So possibly August.
Sorry, Ms Cole, I apologise. I just want to be very clear. So you were involved in discussions with the Treasurer's Office, or you were not? Because that's not clear from your answer.
I have had discussions, regular interactions with Treasury, as you might expect, and limited interactions with the Treasurer's Office.
Ms McCann, are you aware of discussions with the Treasurer's Office on this issue prior to July 2021?
Prior to July 2021, no, I'm not, Deputy Chair. That's not to say that they may not have happened, but I wasn't involved.
Thank you. Ms Press, from an ASIC perspective, when did ASIC first engage with the Treasurer's Office on the issue of not-for-profit funds potentially needing to change their trust deeds in response to the Section 56, 57 change?
Dr. Lee, given that APRA is the lead regulator on this issue and was taking the lead on it, we didn't engage formally with the Treasurer's Office on this issue, although I personally had a number of conversations with Senator Hume's office prior to, at the beginning of 2021.
So the beginning of 2021, you flagged to Senator, or discussed with Senator Hume's office the potential change to trust deeds by not-for-profit funds?
The implications of the changes to Section 56, but it was more informal conversations as opposed to direct consultation.
Just to run through those answers then, so we've got Treasury engaging with the Treasurer's Office from November 2019 on this issue, APRA from July 2021, ASIC with Senator Hume's office from the beginning of 2021. So it does seem from all of the agencies before us that there's extensive engagement with the government over this issue going back over 2 years. Can I ask, I suppose this is a question best put to APRA. There has been an allegation raised that the changes that not-for-profits funds have made mean that there's no incentive for trustees to undertake their duties with care and diligence. But I want to ask you, Ms Cole, is that really correct? I mean, a trustee couldn't use money in the set aside that was to pay fines for criminal behaviour or for willfully dishonest behaviour, could they?
Well, not if they're behaving properly as trustees in accordance with the provisions that apply to them as trustees, whether they be statutory provisions or APRA standards, no.
So there'd still be...
Sorry, your question's to the money though, isn't it?
Yes, so I'm just trying to ascertain the money that has been set aside. It can't be used for any penalty which is imposed on a director, can it? I mean, a criminal penalty imposed on a director would still have to be paid by that director personally, wouldn't it?
Well, I would say in reality, yes, Ms McCann can correct me. I think the point is that the way these reserves are now held is on the balance sheet of the trustee. So where the trustee and therefore no longer members' assets, Deputy Chair, I'm sure you're aware of that distinction, and therefore where the trustee to behave improperly, there would be less APRA touch points and levers of control over a fund that is sitting on the trustee balance sheet as opposed to specific assets. That's why I think there's another idea would be to repurpose the ORFR to hold the risk reserve within it, because that would give APRA greater touch points of control.
But I suppose I was thinking of the Corporations Act restrictions on financial penalties being paid in instances when the directors haven't acted in good faith, such as behaviour that's willful, deliberate, dishonest or criminal. I was just trying to elucidate from you that these sorts of funds couldn't be used to pay penalties which were imposed upon a director not acting in good faith, could they?
I think that is right. That wasn't at the forefront of my mind. Ms McCann will help me out.
Yes, that's correct. And I mean, being a Corporations Act provision, Deputy Chair, I sort of hate to wade into ASIC's territory. I can see Ms Press is ready to get off mute there.
Yes, sorry, I should have directed it to you, Ms Press.
I was going to confirm that is correct, that if it's an individual, the criminal charge against an individual director, it would not be paid out of that reserve. So
you'd still have a deterrent against behaviour that by a director that wasn't in good faith, wouldn't you? There's no suggestion that setting up this sort of a reserve fund would mean that directors could get away with murder, as it were.
I don't believe so. If they were breaching individually, having a criminal charge, then yes, it would not be paid by that reserve. Using a double negative.
But can you get P&I insurance for that under the corpus law?
I don't think you can insure against criminal malfeasance.
Thank you.
So we'd still have a deterrent against that sort of exceptionally poor behaviour. In terms of the question as to whether funds could still be called not-for-profit, Ms Cole, there's no sense in which a trustee who retains earnings in a trust company for the purpose that various not-for-profit funds have done so, that wouldn't create a situation in which the fund couldn't call itself a not-for-profit fund, would it?
I think that statement is right legally, but given that ASIC take the lead on such issues, I think they can probably be more fulsome in their response to you, Deputy Chair.
Thank you, Ms Cole. Whether a particular statement about a profit to member fund is misleading will obviously depend on the circumstances and all, and as the case and the matter of potential misleading conduct. Having said that, we don't believe on the face of it continuing to use profit for member alone is likely to be misleading. And we would note, or I would note here, comments from all of Justice Blue, Ward and Henry to the effect that these fees do not give rise to a profit.
Which makes sense, presumably because these funds aren't paying dividends out to shareholders. The trustee capital remains that of the members in the event that the fund was to be wound up.
That's correct.
Final question, and then I'll move on, allow others to ask. Ms Cole, what's APRA's position overall on trustees being able to charge a trustee to build capital in response to the Section 56 and 57 changes?
Well, Chair, I think as the courts have found, it is legally permissible. And our paper on trustee resilience that we're consulting on, got out for discussion at the moment, is intended to gather up responses on a range of structures and sources of funds so that we can be sure that we can correctly frame, if necessary, future prudential standard directed to the issues on trustee resilience.
Thanks very much.
Thank you, Deputy Chair. Commissioner Press, could I please ask you a question which the Deputy Chair was prodding? So with Justice Blue makes it quite clear in his judgment, and Justice Ward as well, that once this fee is paid, and I believe Ms Cole has made this point too, that once this fee is paid, the money is transferred from members to the trustee to be used as they see fit. So the question is this: on insider trading, if you were to impose a penalty for insider trading for breaching covenants in the SIS Act, that money could be used out of that fund to pay those penalties, right?
Always reluctant to answer this question because I think it does depend on the circumstances. I might ask my colleague Ms Eccleston if she has a stronger answer than that.
Thank you.
To the extent that that's the express reason why that reserve exists to pay penalties, then one would presume that if a penalty is imposed, yes, it will be used for that purpose.
Okay, thank you. So I note that you've separately been investigating superannuation funds, including trustees of superannuation funds who've engaged in switching of investment options with inside information. I guess it would be good to understand that what you are ultimately saying is that A, an investor can lose because a trustee breaches a SIS Act covenant, for example, putting their interests ahead of the members of the fund by switching investment options based on inside information, and B, that the trustee in these circumstances can be fined for breaching a civil or criminal law provision, that they can essentially then levy a fee on members to pay for this penalty using contributions which can only have come from the members' assets of the fund.
Again, we are looking at that issue at the moment. I would have to say that it's not a position that we can comment on whether we will be levying any fines or taking any issues to court at this point, as the investigations are still on.
Understand. Sorry, Commissioner Press.
Excuse me, Chair, can I just add as well that that conduct, when looking at particular individuals, you start falling back in the issue that we were discussing further, whether the trustee itself as a company is in a position to pay a penalty which is levied on a trustee director. So there's restrictions around that we were discussing a few minutes ago.
Sure. Thank you. Commissioner Press, is there anything further you'd like to add? No? Okay, so is it the position of ASIC, with the situation that I've just described above, and Ms Eggleston, that you confirmed could arise under the current law, and these funds that have now been established without anyone representing the interest of members, I think as we've now determined out of today's hearings, where a member essentially loses twice. They get ripped off by the trustee and they get charged to pay the fine to the trustee as incurred. Is that a situation ASIC's happy with?
Mr. Polensky, I'm not sure that it's a position for me to be happy or unhappy with. It is the position that the law has allowed.
Okay, so that is the current state of affairs because of these cases.
If the penalty was levied against the corporate and not against an individual, then yes, I believe that is the case.
Okay.
But it depends very much on what the court.
Sorry, Commissioner Press. No, thank you. Is it correct that the reserves which are now able to be established by reason of the Q Super case in Queensland and the Australian Super case in South Australia will be able to be used by the trustee to pay civil penalties incurred by itself or its directors?
If the civil penalty is on the trustee, then yes, I think that is the case, and that is the outworking of the legal position.
Thank you, Commissioner Press. It's correct, isn't it, that civil penalties can only be incurred in Australia if a court finds that the person or entity is engaged in illegal conduct?
Yes.
Okay. Even if the person admits the illegal conduct, the federal court has to approve the settlement, doesn't it?
Yes, civil penalties are set by the court.
Thank you. What types of illegal conduct would attract civil penalties for a director of a superannuation trustee?
I might ask my colleague, Ms Eccleston, to give you some high levels. There are many civil penalties, though, within the Corporations Act and the SIS Act, which could be levied on a trustee.
Yes. So if we're talking about the directors themselves, there's some specific ones under the SIS Act. Obviously, there's some that apply under the Corporations Act as directors' duties. There's other possibilities, such as being involved in contraventions. It's sort of how long is a piece of string.
Okay. Ms Eccleston, let me go to Section 52A of the Superannuation Industry Supervision Act 1993. Do you have that act with you by any chance?
Yes, I do.
Oh,
Thank
fantastic. I always love it when the answer to that is yes. All right. So I have it here too, somewhere. Do you mind reading 52A out, please? Or I can read it if you prefer. So under Section 52A1, acting honestly in all matters concerning the entity. If I go to C, paragraph C, to perform the director's duties and exercise the director's powers as director of the corporate trustee in the best financial interests of the beneficiaries. Going back to the Q Super and Australian Super decisions in Queensland and South Australia, can I confirm your understanding that the amendments to the trustee deeds accommodates for the use of a reserve to pay civil penalties incurred by the superannuation trustee and its directors?
So I'd prefer not to comment on specific trust provisions. As we've mentioned earlier, APRA took the lead in the sort of detailed engagement on the court matters. One thing I would say is, though, it's always been the case that there's had been liabilities for both trustees and directors. In a sense, the changes to the SIS Act are just changing the source where the money it come from, in a sense of it's much stricter that it can't come out of the fund. It needs to come from another place.
All right, so I think you've confirmed previously, and while you're reluctant to step on APRA's toes that that is the case. So in a hypothetical example, a director of a superannuation trustee is found to have or admits to dishonest conduct in a civil case will not have to worry about the civil penalties because the member's money is able to be used to pay his or her penalties.
I am not sure I could comment on whether a director would worry or not. One would hope that as a fiduciary they would be worried.
Okay, but in terms of worrying about putting their hand in their own pocket to pay those fees or fines or penalties, they no longer have to because of these reserves in this hypothetical instance.
Chair, could I clarify that in the past, what Section 56 provided was that there was only a very limited penalties which were called out as not being able to be taken out of the trust fund. In a sense, the changes to Section 56 have clarified and tightened those restrictions.
Okay, so can I take you to paragraph 231 of the Australian Super decision? Looking at that paragraph by His Honour, it is accurate to say that civil penalties of a dishonest director of a superannuation trustee are now able to be paid out of members' money.
Sorry, Chair, can you just repeat which paragraph you were talking about?
Paragraph 231.
I'd really not to sort of prefer not to answer on the run in terms of just reading the paragraph and responding to it. I'm happy to come back to you.
Well, Ms Eccleston, I put it to you that His Honour is very clear in this instance that once the fee is charged and the money is transferred to the trustee, it sits on their balance sheet and can be used as they see fit. So the answer to my question is yes. Is it still the case
You're
that...
asking and answering your question.
Well, someone has to. So is it the case, and in fact Ms Cole has also confirmed that as well. So is it the case...
I don't think I was asked the question, Chair.
Sorry, Ms Cole. Yes, Ms Cole. Fair enough. You were actually answering Dr Lee's question, at which point you said to Dr Lee, as you would understand, once that money is charged, it ceases being the property of members and sits on the balance sheet of the trustee. Have I misrepresented what you said?
Oh, you are absolutely right. I also said that it's subject to constraints over proper behaviour by the trustees, which in fact Justice Blue alludes to in paragraph 231.
Yes. So, and what I'm seeking to establish here, which I think Justice Blue does, is that those funds that have been taken from members can now be used to pay civil penalties that have been put upon a director of a superannuation trustee.
I believe that we confirmed that.
Sorry, Commissioner Press. Sorry. Yes, you can.
Yes,
okay, thank you.
I think that's correct.
Okay. So, Commissioner Press, people are compelled, and I know the answer is to this question is yes, but people are compelled to put money into superannuation funds. That's the case in this country, is it not?
For most Australians, that is the case, yes.
For all working Australians, that is the case. As of legislation passed last night, I think anyone who earns $1 in this country. Yep.
For all working, not all Australians.
I was there at 5:01 a.m. when that legislation went through the House. This is not a voluntary speculative investment, is it?
It's not it is a compulsory superannuation system.
And the intention of this money is for the retirement purposes of the members, but it can now be used by the trustee to pay for penalties incurred by reason of it or its director's illegal conduct, as found by a court.
Mr. Polinsky, I think you are leading a statement here. I'm not sure I understand the point of the question. It is a compulsory system. Superannuation members can choose whether they are in this fund or another, whatever fund. It may be paid from there, or it may be paid from shareholder capital from another fund.
Sorry.
Here, is it possible if I could just step back a moment?
Absolutely, Ms. Quinn.
Prior, as I mentioned earlier, Section 56 has been in place for a long time, covering a narrow range of possible penalties. The government's response to the Royal Commission expanded the number of penalties that could not be drawn directly from members' funds.
Sorry, Ms. Quinn, I'm sorry to interrupt there. Please point to me the word directly in the legislation.
So the legislation is not drafted in that way. It says that the members...
So either directly or indirectly?
No, that's correct, but it also doesn't say that members' funds can't be used.
Yes, it does.
It says that an indemnity can't be provided.
Would you like me to read from Section 56 too?
So it talks about an indemnity being able to be provided. And so it's the case before and after changes to Section 56 that fees were able to be drawn from members'
I've told
assets.
Robin we're going to go over. Sorry. Thank you, Ms. Quinn.
So it was a case before and after the changes to Section 56 that fees were being able to be drawn from members' assets for trustee use. It's the case that that transaction of moving fees out of assets and into trustee balance sheet is covered by a range of regulatory obligations, some of which have been expanded and tightened, including the best financial interest of members and the change in the presumption of that. So it's the case that it's not that trustees can willy-nilly take money out of members' assets and use it willy-nilly how they wish. That's not the regulatory architecture of the superannuation system. There are a great many obligations on trustees, and the ASIC and APRA have had expanded powers and expanded resources to be able to protect members' assets. So I just want to be clear that if we go from now, comparing it to 2 years ago, certainly the Treasury's understanding is that the regulatory regime is now more transparent and more heavily regulated in terms of how members' assets can be used. So I wouldn't want to give the impression that we've gone backwards in terms of protections for members.
Well, Ms. Quinn, it is my submission to you that we have. That in actual fact, that the purpose of this amendment was to stop members' funds from being raided for the purposes of trustees to use as they wish. And that is precisely through these court cases what we've ended up with. So I go back to my original question, Commissioner Press, which is this, that now under these court rulings, funds can be raised that then become the property of the trustee and can be used for the purposes of paying a civil penalty for a director in circumstances where they have been found guilty of insider trading. Sorry, Commissioner Press.
I'm sorry, I think it depends on what the guilt on the insider trading is, whether it's individual level or whether it's trustee level, whether it's criminal or whether it's civil.
Well, it's civil.
So I don't think that statement can be blanketly made.
So in my question, I stated that it was a civil penalty for insider trading by a director. I mean, I want to be wrong, Commissioner Press, I want to be wrong, but I can't see anything in these decisions that will not allow a trustee to pay a civil penalty on behalf of a director. I can't see anything in the corporations law. I can't see anything in these decisions. In fact, Justice Blue makes it quite clear that once the Yep, sorry.
I think that is true, Mr. Falinsky. I think my concern is that we're talking about an insider trader hypothetical case as opposed to a
Thank you. And that's not an unfair point. Thank you, Commissioner Press. Can I ask you then, so the very people in charge of investing the members' money and only acting in the best financial interests of the members can act in this hypothetical situation dishonestly, and the penalties are paid by the very members for whom the directors acted dishonestly?
Whether or not that reserve or that capital is used in that way is very much a decision of the board at the time, the same as it is in any fund.
Thank you.
Be it industry, it's the same decision to make.
Thank you. So can I follow that up then with this question, which is, if the trustees or its directors use the members' money for purposes that are not in the best financial interests of the members, for example, political advertising, the New Daily, etc., once again, any penalties that arise are able to be paid by the members?
On the surface, that's correct, yes.
Okay. So thank you, Commissioner Press. So logically, therefore, a director of Australian Super, and I stress hypothetically, can, not that they ever would, but can misuse members' money, and when they face a penalty for that illegal conduct, the members pay the penalty, not the person who has acted illegally.
In your hypothetical, that is true of all trustees, no matter which part of the industry.
So,
excuse me, Chair, can I just add, I think it depends on how you're characterising members' money.
Ms Eccleston, sorry, yes.
In the sense of, say if you had a retail fund that did some wrongdoing, in future, what they might do to really recoup the money that they've had to pay for a penalty is to increase the fees on the members. So in a sense, that's also coming from the members. It's just in a different mechanism. So I suppose it's just sometimes members' money is being referred to as coming out of their pocket. Sometimes it's being referred to as the trust funds. There's sort of subtleties in some of the language, I think.
Sure. But where else is it coming from if it's not coming out of their pockets?
It's true. I suppose the point I'm trying to make is that in all forms of structure in the superannuation industry, you could basically articulate that at some point members may suffer through wrongdoing of the trustees. And that's why it's been so important that there's been so many changes to the law to increase accountability, and also in terms of the law, and also the regulators, being very active in this space as well.
Okay. And it's on that point, Ms Eccleston, or Commissioner Press, sorry. Given everything that I've described here as a possibility that is live and active and for which there is great incentive to act upon, why didn't ASIC intervene in these cases?
Mr. Falinsky, it's not ASIC's role to determine the effectiveness of Section 56, Part 2. And appropriately, this has gone through the courts. And we believe that APRA was representing the regulator's views as the lead regulator in this case. And it would not have been a good use of the courts for us who have done exactly the same thing as APRA did.
Commissioner Press, when it comes to financial products, which regulatory agency has responsibility for consumer protection?
For financial products generally, ASIC has a role in consumer protection.
Do you consider superannuation to be a financial product?
Yes, I do.
So are we not talking about potential harm to consumers?
Mr. Felinsky, the question you asked me was why did we not appear in this case? And it was because it was not our role to do so, and APRA was appearing. We had worked closely with APRA to ensure that any concerns we had were addressed by them, and it would not have been, in our opinion, a good use of the court's time to have heard two regulators saying exactly the same thing.
So you informed APRA that there was potential consumer harm in these decisions?
We had a number of conversations with APRA on these cases across the board around the best interest duty, around the things that funds should consider, and around any of our concerns that we had with the change here, and APRA articulated in the same way as we would have.
Okay. Could I ask, do you think rather than an unbridled reserve, which has now been set up, causing potential consumer harm for a product that Australians have no choice but to buy, that permanent, according to Justice Blue's decision and the Q Super case and all the other 9 cases, permanently removes from the members' corpus and, according to the Blue decision, is not thereafter subject to the safeguards of the SIS Act as to its use? Would it not have been better to have that reserve still under the observation of yourselves and APRA?
I think I challenge the unbridled nature of the reserve. I think there are any controls around the changes in the trustees. Having said that, the law that was passed by the Parliament said that this could occur, and the courts have allowed it. Do I personally think it could be better held in the operational risk reserve and the circumstances of that? I think I agree with Ms. Cole's comments at the beginning that yes, that would have been another way.
And
but that is not what the Parliament decided.
But did you make that submission to the court? Did APRA make that submission on your behalf to the court?
That is not about what this was about. This was about the interpretation of a legislation that had been passed by the Parliament.
Really, Commissioner Price?
That conversation was prior to it being passed, and we had a number of different conversations around what other alternatives might have been, but this.
Commissioner Press, Dr Molino has some questions, and then I'll come back to Treasury. Thank you for your submission, your evidence, rather. Dr Molino?
Oh, thanks, Chair. And apologies if drilling starts directly above my head, but there's major refurbishments going on in this building, annoyingly. Look, I just had a couple of quick follow-up questions, and one was following up on the discussion that was just occurring with the Chair, Commissioner Press. So in relation to whether you should have intervened or why you did or didn't, I just wanted to clarify ASIC's role in relation to section 56(2). It's fair to say your role is not to advise the government on the specific wording of a new provision such as section 52 on the policy implications. That's not your role.
Dr Molino, do you mean section 56(2) or section 52?
Or any section.
Oh, okay.
Dr Molino, that is true. I mean, ASIC is a stakeholder and a very interested party. We make submissions to any changes.
Sorry.
But it is a matter for the Treasury and the Parliament to pass the law.
Yeah, and look, I mean, as Ms Quinn indicated, Treasury is there to advise government, but ultimately it's the government that puts pieces of legislation to Parliament, and it's Parliament that debates them and passes them. So,
correct. As we're very clear, we are not a policy.
Yeah, and then, and as you said, it's not ASIC's role to interpret the impact or the effect of the specific wording of any new provision. And as you indicate in a letter that was distributed to the committee, there have been a number of court decisions recently in relation to the effect of the specific wording that was passed by Parliament. And in all 9 of those cases, it was found by the courts that a risk reserve is essentially permitted under Section 56(2).
That's correct.
Yeah. So just to clarify, I just wanted to clarify that particular aspect of your role as a regulator. So look, in a similar vein, just more for clarification, I just wanted to follow up in a sense on some of the questions that have been raised in relation to APRA. So specifically, Ms. Cole, you outlined the ways in which you intervened in some of the court cases. I just wanted to ask very specifically, you chose a particular way to interact with those cases as an organisation. Did you feel that the way in which you interacted with those court cases, APRA was able to provide all relevant information to the court for the court to take into account?
I do feel that we were able to do that, Dr. Molina, and also we played the role of pushing the applicants to provide information. Sorry, there is a lot of background noise. It's hard to hear on here. But yeah, we made sure that the applicants, the trustees in this case, put in information sufficient for the court to take into account relevant issues as well, their own information, that is. So I feel we were thoroughly, we were given time to make our submissions, and we were heard by the court.
And it's fair to say that one of the factors that APRA took into account in making its submissions was the importance of the stability of the overarching system, which in turn is, in broad terms, in the interests of members.
Yes, I mean, as a prudential regulator, that's front and centre of our mission. But we also made sure that we and the court paid a lot of regard to the best financial interests of members.
Great. So look, there's been a lot of discussion about whether APRA should have intervened in this or that role, but look, fundamentally, the point is that APRA was able to provide the court with relevant information. The court then took that into account as it saw fit and made decisions. And I might say across 9 decisions now has come up with consistent interpretations of that section.
Yes, there are some technical distinctions between being an intervener and being an amicus, but it makes no difference to the way that we're able to make our submissions of the information we can provide to the court.
Yeah.
I do have to say,
sorry, Ms. Cole. I think, Ms. Cole, I'm sorry to interrupt you. I do that rarely, I know. But I think the distinction was between amicus and contradictor, not intervener, sorry.
Yes, but as a contradictor, we would have had to have taken an opposing position on the law, and we did not do that because that was not consistent with our legal advice. And I just wanted to add in response to Dr. Molina and another comment that was made earlier, I don't think it was for APRA to make submissions to the court about alternative forms of statutory drafting, alternative methods of holding the reserve. It's a policy matter for the government.
Yeah, I think that's an entirely appropriate stance to take myself, given APRA's role as a regulator. Look, I just wanted to ask a couple of quick questions on the $100 million issue. Now, look, I don't want to get you in a position of supporting that figure or not, but it's fair to say that there's no reason to think that there's anything untoward in Australian Super's calculations. That isn't to say that you necessarily agree with them, but I just want to. Some of the suggestions are that that there might be something malicious or mischievous in that calculation. There's nothing to date that's arisen that suggests that there's anything inappropriate in their calculations.
Not that I know of. I believe Mr. Silk and Mr. Schroeder, according to para 70 of the judgment, gave evidence to the court. I'm sure that they would be mindful of the need to explain why they were saying this to the court, and probably their evidence is on the record somewhere to be looked at for anyone who has any concerns about it.
And I think you've already said words to this effect. I just wanted to, I suppose, have it again on the record. Notwithstanding the fact that you're not in a position to stand behind the $100 million figure or not, it's fair to say that you're confident that regardless of the particular figure in a particular case, with a very large fund with complicated IT systems, the costs are likely to be very material, and those material costs will ultimately be borne by members should a trustee need to be replaced.
I would agree with that proposition, yes.
Okay, thanks. Now, the last question is really, and I'm not sure whether this is more appropriate for APRA or Treasury, so please either Ms. Cole or Ms. Quinn jump in. Look, I don't want to ask a kind of a policy position. I simply wanted to, by way of context, ask a question around individual trustees bearing the potential of significant liabilities personally. That isn't what occurs broadly at the moment. We don't see widespread instances of trustees of superannuation funds bearing large civil penalties themselves. I simply wanted to ask, if it were to be the case that people perceived that there was a material risk of that would have consequences in terms of people's willingness to become trustees, I would have thought. So maybe...
That for me or Ms. Quinn?
Well, Ms. Cole, do you have thoughts on that? Because that would have implications for the stability of the system, I would have thought. If there was a marked increase in a lot... There have been some suggestion by some people that individuals should potentially be liable for any civil penalties or many civil penalties that funds might be held liable for. If we were to go down that path, which we haven't to date, it's fair to say that would have, in all likelihood, consequences for people's willingness to be trustees, and that could have consequences for the stability of the system as a whole.
I think what I'd say, Dr. Merino, is it's vitally important that super funds are able to attract high quality, capable directors, and that anything that chills the willingness of people with the right degrees of right capability and skills from being prepared to act as directors of super funds would be a bad outcome.
Ms. Quinn, do you have any thoughts on that? Without asking you your views on the particular calibration of, I'm just simply asking a more empirical question, I suppose.
Thank you, Dr. Merino. I would agree with Ms. Cole about the importance of the capability of directors of superannuation trustees and other trustees in the financial system more broadly. I would note, though, that we have a regulatory regime that also balances the role of those directors and the obligations they have. So directors don't have unfettered actions. They have got a legal framework they must operate in, and it's very clear that there's a great deal of governance reform and regulations, both at the individual, through the licensing regime, through the prudential standards, through the conduct regime. The superannuation industry is one that's characterised by a great deal of regulation to protect members' interests. So just to balance that clearly we need good people to take on these responsibilities, but they are also within a regulatory regime to ensure that money is safe for members.
Thanks. And so the last question I have, and this is, again, could be to anybody in a sense, but there was a discussion with the previous witness in relation to, the appropriateness.
I got 6 more questions.
The appropriateness of nominators, as in employer groups or unions, being held liable instead of individual trustees, because I think it's broadly accepted that the system would struggle if individual trustees were to be held liable, very, very broadly for any civil penalties that were incurred by funds. the previous witness thought that it would be unusual and I think it's fair to say inappropriate for nominators to be held liable for a range of reasons, one of which was that would then reduce the independence of the trustees that were nominated by those organisations. Do you have any views on that, Ms. Quinn?
So I have nothing further to add to Dr. Donald's submission or evidence that he gave. The fundamental point is that we have a governance structure for trustees that requires them to act in the best financial members. There's a great deal of attention in the regulatory regime to ensure that happens, including supervisory behaviour and other forces. So that's the fundamental principle, service and best financial interest duties, and it's very important that that's maintained.
And so when you say you don't have anything further to add, would you be broadly aligned with the position he put?
So at the risk of repeating myself, it's important that trustees act solely for the sole purpose of the best financial interest duties of members, and anything that cut across that in terms of confusing accountabilities, etc., would not be a sensible thing.
Okay. Thanks, Chair.
Thanks, Dr. Molino. Can I ask Treasury, Ms. Quinn, I believe, do you recall comments at the Royal Commission hearing, Senior Counsel assisting the Commission, Michael Hodge QC, asked, with respect to superannuation industry, what happens when we leave these trustees alone in the dark with our money?
So I did not, I was not witness to that part of the Royal Commission.
Okay. What do you think motivated these comments? What was being suggested, do you believe?
So going on the face of the quote that you've said, I mean, this is very important in the financial system in general, but in the superannuation sector, that there's transparency, accountability, and strong regulators against clear laws. And it's important that the actions of all parties who are responsible for others' money are transparent and accountable.
Okay. So what do you think was the stated policy intent of the changes to Section 56?
So the changes to Section 56 was, as outlined in the statute, is to ensure that to prevent trustees and directors from being indemnified from trust assets to pay civil, criminal and administrative penalties incurred under any form of...
Okay. So can I refer to the executive memorandum which states 9.165, in view of the extension of the Australian Financial Services licensing regime to cover the provision of superannuation trustee service, Schedule 9 also extends the existing indemnification prohibition, specifically sections 56 and 57 of the SIS Act, now prevent trustees and directors from using trust assets to pay a criminal, civil or administrative penalty incurred in relation to a contravention of Commonwealth law. 9.166, this means that a superannuation trustee or a director of a superannuation trustee cannot use trust assets to pay a penalty that they've incurred for the contravention of a provision of the Corporations Act or ASIC Act. Is the law operating as intended based on the comments put forward in the EM?
So the this provision has this provision is preventing trust. Is preventing indemnification.
Sorry, Ms. Quinn, I'm just going to have to suspend the hearing for about 10 to 15 minutes. We have a division in the House.
Thanks very much for giving evidence, everyone. If we don't come back, really appreciate your time.
No, we're coming back. You were saying?
Sorry, Senator, at the start of your statement, you didn't come through the...
Sorry, my apologies, Ms. Quinn, you were saying?
So just remind me of your question. I think the question was...
Oh, sorry. Can I also say I have no further questions for ASIC. I'm sure they'll feel disappointed, but if Commissioner Press and Ms. Eccleston would like to leave, I don't wish to detain you. Given what was in the executive memorandum, Is the law operating as intended based on the comments put forward?
So the law is operating to prevent indemnification of trustees and directors' penalties. That is the way the statute is drafted, and that is being prevented. What has been found in the court processes is that for a trustee to pool funds through a fee to build an operating reserve outside the trust assets has been found not consistent with that Section 50 amendment. But it is the case that the indemnification is operating as drafted. It is the case that penalties can't be paid out of members' assets within the fund. But it's also the case that this section does not prevent fee being drawn into trustee balance sheet for the use of operational resilience.
Okay, so I guess my question to you is, you've already said that you were in discussions with superannuation funds and the sector in general to determine how this might be implemented. Did you foresee that or did you anticipate the trustees would adjust their trust deeds in the way that they have?
We did foresee that it was possible that all superannuation funds, depending on what their trust arrangements were, could use fees to build up a reserve. This was actually happening prior to the 56 changes.
Sorry, specifically, Ms Quinn, did you anticipate that they would introduce new fees and change their trustees to allow them to introduce new fees to set up the funds that they have?
So we were aware that some funds were not able to draw fees in the way that other funds could do, given the diversity of arrangements in the system. We weren't aware of exactly what trustees would do, because that is a matter for them to determine under their obligations in the system.
Okay. Did Treasury advise government at the time that this was a possibility?
It was. So when advising on the legislative change, we did discuss, there was a range of analysis done, and it was a possibility that funds would use other mechanisms to pay fines. They can't pay fines, administrative fines, for example, out of, they could be indemnified for the administrative penalties. We did note that those penalties would need to be paid from other sources.
So these fees, which now circumvent the intent of the law, you advised government at the time that this would be consistent with the spirit of the changes in the law? And when I say you, I mean Treasury. I do apologise. Did Treasury advise government? Sorry.
Sure. There's quite a few twists and turns in that question, Senator. The bottom line is that we were very clear in the legislation that this prevention and indemnification, that is how it's being operated. That operation is happening. But Section 56 operates within a whole system of regulations and obligations. It's the case that funds are able to draw administrative fees from funds. The purposes of those administrative fees can be to pay penalties. That was the case before Section 56 was changed, and it's the case after Section 56 has been changed. Okay.
So do you think the outcomes that we're now observing means trustees are no longer in the dark with our money, given what has transpired?
I think that the changes to Section 56 have made it very clear that there can't be indemnification within members' assets. That's meant that if trustees wish to draw fees out of the fund, they have to be very clear about what the purpose of those fees are. That is the case in the court actions. It's also the case for those that have not gone to court that wish to draw fees out. They are obligated under the changes to the Act for Best Financial Interest Duty that they need to make it clear that it is in the members' best financial interest to do such in terms of drawing fees. It's also the case that the transparency around fees that superannuation trustees levy has increased through the Your Future, Your Super regulatory changes. Any administrative fees that trustees draw from a fund are very clearly accounted for. They go into APRA's heat maps, and there are performance obligations and standards on superannuation funds. So taken together, these changes with other changes, I would contend that the net result of the changes in the superannuation system as a result of the Royal Commission recommendations and the implementation and the government's reform agenda on your future, your super, that there is a greater transparency of fees in the superannuation system and the implications they have for members. And those fees go to many things, profit, but also operational costs of a fund.
Okay, what advice did you seek on this?
So we did seek legal advice on when developing the legislation in response to the Royal Commission. We did seek legal advice in relation to the operation of Section 56 when it was clear that this issue was going to the...
Okay, did you seek advice from APRA or ASIC?
We certainly had extensive with APRA. The legislation, just to be clear as well, when we have a formal process when legislation is drafted that we consult with the regulators for them to provide advice as part of our advice to government on the implementation of legislation.
And what was their advice to you?
I would have to go back and check on this particular this matter.
Okay, could you take that on notice, please?
Yeah.
Thank you. And to what extent is the financial accountability regime designed to complement the penalty regime and ensure fund executives are accountable for any penalties the funds may incur?
Or Parliament that you're talking about, the financial accountability regime?
Yes.
So there has been careful consideration of how the two operate together. Make they operate effectively as pieces of legislation. So that has been considered both as part of the drafting advice as well as the consultation that we've had with including the...
Okay. Thank you, Ms Quinn. Ms Cole, two last questions. In the Australian Super case, Justice Blue based a number of his decisions on confidential submissions made by Counsel for Australian Super. Have you seen this in any previous cases?
I'm going to ask Ms McCann to deal with that one, please.
Yes, sure. Happy to, Ms Cole. So, Chair, it's the fact that across a number of these trustee court applications, aspects of their submissions were kept confidential. This was something that was sort of put to the court and considered by APRA. Of course, normally you have the open court principle, which is that, of course, evidence tendered in these sorts of proceedings, it's in the sort of public interest for it to be publicly available. Having heard arguments in the court as to why it could be detrimental to the interests of the fund for all of this information to be made public, some of the judges have made confidentiality orders around some of the material that was submitted.
Okay. Did the funds share their submissions with you prior to the cases?
Yes. So APRA was...
So you have seen those confidential submissions?
I'll have to get back to you on notice on that one, Chair.
Yes, please take that on notice. Thank you. Given that there was no one representing the interests of members in any of these cases...
That's just not
And
true.
we've had confirmation before this committee today that members will now be paying civil penalties when they have incurred those losses against them. Are you really happy with the outcome of these cases, given that Ms Cole said earlier that members' interests are first and foremost in the actions that APRA takes?
There was no, but perhaps you're right in saying there was no one formally instructed on behalf of a member in some of these cases. APRA took the view that we would put before the courts the issues that we considered relevant to the best interests of members. So I think the best interests of members were advanced with the medium of APRA as amicus.
And so we've ended up with this outcome. Yes,
And,
sorry.
and if I could add to that, as we've said earlier, Chair, in a number of these matters, there was a contradictor or
Ms.
member
Ms.
representative.
McCann, I'm sorry, but we've already discussed in the Australian Super case that the contradictor was represented by the law firm established by the council representing Australian Super. This was not a contradictor appointed by the court. Did APRA make an argument for a contradictor to be appointed by the court in any case to represent the interests of members?
No, we did not,
Okay.
but I would just...
And so now we've ended up in a
situation
situation where members will be paying civil penalties on behalf of trustees. I don't know how that's consistent, sorry Ms Cole, with what you said earlier.
I think I need to emphasise my previous answer. APRA instructed senior counsel, external lawyers in each of these cases, the majority of the cases, to put forward to the court the views that we considered were relevant to the question of best financial interests.
Ms Cole, let me...
That we behaved appropriately there.
Sorry, Ms Cole, let me ask you one last question. At any point, did any of the legal advice that you took or any representations put forward to you, because we know you were talking to the trustees a lot and you had round tables with the trustees, there's all these conversations going on between the regulators and the trustees who have benefited from this arrangement. Did anyone at any point, at any time, in any court case go, hey, should there be someone here making the argument for members?
Well, there certainly were contradictors.
Ms Cole.
I have to correct the premise, I'm afraid, because in those round tables,
Ms Cole. Sorry, Ms Cole.
which were
Yes.
before my time, there were representatives from a complete range of people across the industry, including the FRC, who were fully informed, and others across all different types of stakeholders. So.
Well, Ms Cole, maybe you can provide it. Maybe you can provide us.
Was,
Ms Cole, maybe you can provide us with the list of roundtables you had and who the stakeholders were and how many you had, because the evidence in front of this committee at the moment.
I'd certainly be happy to do that.
That would be great, because the evidence before this committee at the moment, and so we are suffering under a misapprehension that the vast majority of the conversations that occurred between the regulators were between the regulators and the trustees. We've had confirmation here that APRA at no point made any submission to the court that a proper contradictor should be appointed in these cases. And we now have a situation where civil penalties will be paid by the very members who have suffered because of the actions. Because of the actions. In fact, can I, just to ask this question, did anyone at APRA at any point speak to a fund member?
I would have to take that one on notice.
Thank you, Ms Cole, I do appreciate it. Thank you very much. All of you have been incredibly patient, including the Deputy Chair, and I do appreciate your time here today. Can I have a resolution that the committee authorise publication, including publication on the parliamentary database, of the transcript of the evidence given before it at the public hearing today?
You can, though I do need to correct one point you made, Chair.
Yes.
In the Australian Super case, the contradictor was represented by a different law firm from
Yes.
Australian Super.
Sorry, let me be clear. The law firm that represented the contradictor was the law firm established by the barrister representing Australian Super in that court case. Does this make sense?
It makes all the same sense as someone trying to deny the moon landing with strings and bits of wire.
I see.
Connections.
We're going to have
over the
this
place.
argument offline.
There
That's
was a
on Hansard.
contradictor. They were represented by a different law firm from Australian Super.
There was not a court-appointed contradictor. But anyway, look, we're getting into an argument that you and I can have.
I'm happy to move that resolution.
Thank you. I appreciate that. There being no objections, it is so resolved. I declare the public hearing closed. Thank you.